In 2023, His Excellency Rigathi Gachagua, according to the National Assembly, recklessly and mindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Subarticle 5 of the Constitution. The Honorable Judge, according to the National Assembly, had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency the Deputy President to forfeit to the state the sum of 200 million shillings, which he had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks, according to the National Assembly, are impeachable offences to the extent that they undermine the functional and decisional independence of judges. If you're just joining us, these are live pictures from the Senate chambers where the trial has taken a short break. The Speaker has gone to draw a ruling on the way forward for this trial, where the Deputy President has been unable to appear to take to the witness stand. His legal representative, led by Senior Counsel Paul Mwite, has asked the Senate to give the Deputy President until Tuesday next week, and thereafter make a decision on the way forward. The National Assembly, through its legal representatives, led by Senior Counsel James Orengo, urged the Senate to consider the evidence that has already been forwarded by the Deputy President. Quoting the law, the National Assembly, through its legal representatives, argued that having forwarded the evidence in writing, there may be no need to have the Deputy President give his accounts. The team argued that this Senate decision on that, and it is willing to forego the cross-examination of the witness, who is the Deputy President of the Republic of Kenya. So we await the counsel representing the Deputy President. Ground 5 of the
after according the President
Ground 5
an opportunity
that
to be
the National
heard,
Assembly believes is an impeachable
on the
offense
impeachment
is the gross
charges.
violation of
Mheshimiwa
Article
Speaker,
3, Subarticle
we
1,
are aware
and Article 148, Subarticle
this
5A of the
Honorable
Constitution,
Senate
which talks about the
made a
breach
decision
of the oath of
to
office
hear
and
the
allegiance.
charges in
National
plenary.
Assembly, in
So
impeaching
that
the Deputy
what
President,
we are doing
argued that His Excellency
in these
Rigathi Gachagua's
proceedings,
actions and utterances
I would suggest
outlined
and
in
submit
Ground 1,
we are proceeding
2,
under
3, and 4
6
constitute a gross violation
and
of Article
under
3, Subarticle 1 of the
6B,
Constitution,
this House,
which
by the
requires every
Constitution,
person to respect,
is
uphold,
obligated
and defend the
to
Constitution.
accord the
Further,
Deputy
the
President
actions and
an
utterances of
opportunity
His Excellency Rigathi
to be
Gachagua
heard,
grossly violate
which is
Article
why
148, Subarticle
Rule
5A
11
of the Constitution,
of the
which
standing
prescribes the
orders
oath of allegiance
this
of
House
the office of the Deputy President that
specifically
obligates the Deputy
provides
President to obey, preserve,
11,
protect, and defend the
where the
Constitution.
National Assembly or the President
There's also serious reasons, according to the National
chooses
Assembly, to believe
not to
that the
appear.
Deputy President has
And I would
committed a
like to
crime
submit
under national
that the
law pursuant to
Deputy
Article
President
150,
has
Subarticle
not
1B, Part 2 of the
chosen
Constitution.
not to appear. The choice of the
Under
language
Ground 6,
chooses to appear
The National
in
Assembly,
Standing Order
in its
number
submission,
11, is to be
argues that
read
there's serious reasons to
with
believe that His
starting
Excellency
with
Rigathi
the
Gachagua
Constitution
has
Article
committed crimes
145,
under Section
Sub-Article
13,
6,
subsection 1A,
which obligates
and Section
this
62 of
Honorable
the National Cohesion
Senate
and
to
Integration
accord
Act.
the
Section
Deputy
13 of
President
the National Cohesion and
an opportunity
Integration
to be
Act
heard.
provides
So I
that
do leave the
it is an
matter
offense for any
in your
person
hands,
to use
Mr.
threatening,
Mheshimiwa
abusive,
Speaker,
or insulting
and
words or
honorable
behavior
senators.
where the person intends to
I
stir up
would
feelings
suggest
of ethnic contempt,
Article
hatred,
145,
hostility, violence, or
the
discrimination.
sub-article I've read,
The section
sub-article
also makes it an
6,
offense to
B,
use such words or engage in
doesn't
such
have
behavior
a time
when
limit
having regard
of 10 days.
to all the
Give the
circumstances
Deputy President,
ethnic
in the
hatred is
interest
likely
of
to be
justice,
stirred up.
given the weight
The National Assembly
of
argues
removing
that
a
besides
Deputy
Section
President
62 of the
from office,
National Cohesion and
give him
Integration
a
Act
couple of days.
states that a
I thank
person
you.
commits an offense when the person makes statements
if I get you
that are
correctly,
intended
Senior Counsel,
or are likely to stir up feelings
it
of
is your
ethnic contempt,
application
hatred,
to the Senate
hostility, violence, or
that your client be given
discrimination.
a couple of days.
His Excellency Rigathi Gachagua's
Now, a couple of
persistent,
days
inflammatory, reckless, insightful
doesn't
public
mean much.
utterances over the last 2 years, according to the National
That
Assembly,
is
details
the
of which are set out
application.
in grounds 1, 2, 3, and
What I had
4,
in mind, I
establish
would
serious
add
reasons
the
to believe
word
that he has committed
humbly
crimes under Section
requests
13, subsection 1,
Mheshimiwa
and
Speaker,
Section 62
and this
of the
Honorable
National
House,
Cohesion
the
and
Senate, a
Integration
couple of
Act.
days I had in mind up to
Round
Tuesday.
7.
We
Serious
should be able
reasons to
to
believe
know
that His
when
Excellency
the
Rigathi
Deputy President is
Gachagua
able
has committed
to
crime
come
under
and
Sections
defend
45,
himself.
subsection
I
1,
thank you.
Section 46, Section
Counsel for the National
47A,
Assembly.
Part 3, and Section
Mr. Speaker, sir,
48, subsection 1
permit
of
me
the
to start by
Anti-Corruption
registering
and
our
Economic Crimes
greatest
Act, and Section 2,
sympathies
3,
and empathies
4, and 7 of the Proceeds
from
of
the
Crime
team,
and
the National
Anti-Money
Assembly.
Laundering Act.
Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned senior counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did sit, did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that, the matter at hand from a committee perspective, but that the whole House would then be determining the matter. It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did gazette the 16th and 17th of October to be the days assigned for the hearing and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard does not have to be oral. The rules of this House permit that parties appearing could elect to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency, the Deputy President, has participated robustly in the proceedings, both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, if my memory serves me right, let me just make a quick reference. Dated the 12th of... Mr. Speaker, sir, up to this point in time, His Excellency, the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us, because our expectation would be that His Excellency, the President, would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves in, very keenly heard learned senior counsel speak. Matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, cannot be given timelines. There cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty that we'll be able to proceed on that assigned day. Mr. Speaker, sir, we would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law, sir, because I earlier on submitted that Article 50 provides for an opportunity, provides for the right to fair hearing, and that fair hearing does not necessarily have to be oral. We have had practice in our Supreme Court where dealing with some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have, in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight those documents and pleadings that have been filed. In this occasion, because His Excellency, the Deputy President, has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. On our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter, we are willing to take the painful decision to forego the cross-examination of the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency, the Deputy President. Mr. Speaker, sir, we urge that if I heard my learned senior colleague, Mr. Paul Mwite, senior counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 of those rules dictates that once the hearing has commenced, it shall proceed up to the end. It does not provide for adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the procedure, that being a country, being an organ of a constitution that is that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word. before you give your directions. I'm most obliged.
Mr. Speaker, just briefly, in these proceedings, we are governed by Article 145. And there is a very unique provision in Article 145 that you don't find in legislations to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, sub-article 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find ourselves in. The president states as follows, and for that matter, it should appear and be representing its investigation. Now, the point that I want to make, you find the right to be represented, highlighted, because the deputy president either